Hey guys, welcome to my legal classes. This is Ganesh Pujari and we were discussing sources of international law in this series. This is my third video where we are going to discuss international customs as source of international law. Now the next slide is a flying slide which we have already discussed in detail as an introduction to the sources of international law. I'm just giving a glance of that slide and then I'm getting into details of international customs as source of international law. As we have already discussed in my first video on the sources of international law, Article 38(1) of the Statute of the International Court of Justice gives the sources of law as two important sources, that is principal sources and subsidiary sources. And in this video, we are going to discuss the Article 38(1) subclause B, which discusses international customs as evidence of a general practice accepted as law. Now, I am not spending any time on this because we have discussed in detail on this particular chart. So, I am directly getting into international customs as source of international law. The first issue that you need to attend whenever you are starting your answer on international custom is whether custom and usage are same or not. If they are not same, then what is the relationship between custom and usage? That part you need to define. Now, you need not to define. Stark has already defined, saying that usage represents the twilight stage of custom. Custom begins where usage ends. Usage is an international habit of action that has yet not received full legal attestation. He makes it very clear by saying that usage ends where custom begins. Now, when you start using something repeatedly, that becomes usage, and if it is used continuously and consistently, then it gets converted into customs. Now, the difference is usage doesn't have any force of law, but when it gets converted to custom, that gets the force of law. Now, international usage can get converted into international customs. That is what you need to understand. Now, before it gets into international custom or when it gets converted into international custom, there will be two kind of tests, whether they are really customs or not. Now, Stark says there are two kind of tests. One is material test and the other one is psychological test. When he says material test, he refers to length of time and number of recurrence of that particular custom being used. And when he's saying psychological test, he refers to the acceptance by the major jurist in accordance to that particular custom. Now, that is what you need to remember as far as Stark's definition is concerned. Now, the International Court of Justice says in its 38(1)(b) that evidence of general practice accepted as law, by saying that it gives a lot of importance to customs. Now, there are few rules pertaining to usage and customs. Let us understand one by one. The first rule I am buying from Weaver's definition, who says a custom is the usage which has obtained the force of law. When you are saying custom, it is the other form of usage or it is the outcome of usage which got the force of law. That is what Weaver says. The second rule is it is not necessary that every usage should always proceed as custom. Now, there are so many usages. It is not necessary that every usage converts into custom and gets force of law. It is not required. The third one is in certain cases usage gives rise to international customary law. It is not in all the cases. In certain cases this usage gets converted into customary law or international customary law. And last thing, there are four important aspects in a custom that you need to remember. First being duration, then the generality, third one is the acceptance, and the fourth one is acceptance of practice as law or opinio juris. Now, all of them will be covered in my next or the other slide, so need not to worry about them as of now. When it comes to international customs, there are two important case laws you can refer in your answer. First being Western Central Gold Mining Company versus R. In this case, it was held that to consider anything as valid international custom, there are two important requirements. The first being it should get general consent from the states. Second one, it should not be opposed by any civilized state. So these are the two things you need to remember. First being general consent, second being there should not be any opposing by any civilized state. Now, the second case law is Portugal versus India, where it was held that if there is any general practice which was repeatedly followed for a long time, then it becomes binding customary rule. That is what held in the case of Portugal versus India. These two case law are the prime case laws you can refer when it comes to international customs. And Dixon refers custom as the foundation stone of the modern law of nations, and this was backed up in the case law of the Gulf of Maine case. Now, these are the important things you need to remember when it comes to international customs. The next important aspect that we are going to focus as far as international customs are concerned is the essential elements of such customs. Now there are so many essentials that you can refer from different sources, but I have brought 10 important essentials which can cover the requirement as far as exam is concerned. Now, before even we get into essential elements of valid international customs, I would like to read out the definition from Hug, who says the way things have always been done becomes the way things must be done. That means for present and future, it is necessary to refer the past. He gives a lot of importance for customs, and then he says there should not be any difference, or there is no difference between the pattern of international law or the municipal legal system or the state law. That is how Hug sees custom as an important source of law. Now let us discuss the essentials one by one, and you can also call them as essentials or the character of valid customs. Now the first being, custom is regarded as a form of tacit agreement. Now what is tacit? Tacit is a Latin word which means silent. So customs are basically silent agreement. Now they are not really spoken or they are not really recorded. They are being followed by different states for a long time, and they are being accepted by many of the states, and they get converted into customs, and that is the first essential of a valid custom. Now the second one, customary laws can change. As for the requirement of the new society, the customary laws can always change. That is the second essential or second important character of a valid custom. The third essential and one of the most important essential element of a valid custom is there should be consistency or uniform usage. The first case law that we are discussing here is asylum case, because this theory is always discussed with case laws. There are so many case laws as far as consistency or uniform usage is concerned. Now in the first case law, that is asylum case law, it was held that the customary law should be in accordance with the constant and uniform usage practiced by the states in question. For example, if A and B states are bringing certain legal question pertaining to customary law, then it should be practiced by those two states in constant and uniform way. That is the requirement which was discussed under asylum case, which was between Colombia versus Peru. The second important case was Lotus case, where it was again told that constant and uniform requirement is one of the most important aspect as far as customary law is concerned. However, it need not to be totally uniform and constant, but there should be a significant level of uniformity and constant. That is what discussed in Lotus case. However, in the fisheries case, that is United Kingdom versus Norway, it was settled that customs should be uniform and consistent. So there were so many case laws, and finally in this case it was held that they need to be uniform and consistent, and now there is no question when it comes to consistency and uniform usage. Now the next important essential is also a big question. Now, how to decide a custom is a valid international custom? To decide a custom as a valid source of law for a particular state, it is very easy. You need to apply for all the citizens. But when it comes to international law, there are so many nations. So, how to decide the generality of practice? Now, there may be few states which are following, and there might not be other states who are not following. So that is what we are discussing as the fourth essential element of valid custom, that there should be generality of practice, but it is not essential that 100% practice should be there. In the case law of North Sea continental shelf case, it was held that it may be difficult to determine the number of states to participate in international law before a general practice can become law, because it is not about majority of votes cast. The degree depends on the various subject matter. That is how it was decided, and once a practice is established as forming part of the customary international law, all states are bound, including states and the new states that failed to contribute to the practice initially. That is how we are seeing general practice as, or generality of practice as source of or essential of valid custom. The sixth important essential element is opinio juris. That means an opinion of law. Now, customs are not in written form. They are mostly invisible, and there should be some psychological element creating a feeling of legal obligation on these particular customs. That is what very much required, which we are discussing here in opinio juris. Now, opinio juris sive necessities means acceptance of practice as law. That means many nations need to accept the customs as the valid source of international law. And how is that done? By giving Article 38 1b by the Statute of the International Court of Justice, customs are being given high importance, And opinio juris also says that there should be psychological element which should give lot of importance to customs. Now there are so many case laws where there is lot of psychological edge given and customs were treated very important, like continental shelf case or legality of nuclear weapon advisory opinion or Lotus case, or in the case law of North Sea continental shelf cases or Nicaragua case. Now these are very important case laws. What I am thinking is I am going to make independent presentation on all these case laws, because these can be referred in many places, and I will explain there once so that you can refer those case laws and put few facts about this case law in this answer also. The seventh element is jus cognans. That means the principles which form the norms of international law cannot be set aside easily. Now once they are being accepted as the norms of international law, they need to be respected. That is what jus cognans is all about. Eighth one is customs can be bilateral or multilateral, and customs can be general or particular. What is bilateral? Whenever there is a question of two states, that is bilateral. Whenever there is question of multi-states, that is multilateral. Or whenever there is question of many states, then it is general. Or if there are any few specific states, then that is particular. The case law example for this is right of passage over Indian territory case, where it was only between India versus Portugal. Here the customs of India and Portugal only will be seen, that is known as bilateral customs or particular customs. Whereas if there are multi-states are involved, in that case multilateral customs or general customs will be viewed. The next essential is duration. Now when we were studying Hindu law, we studied that no one should be knowing the duration from when we were practicing such customs. That means duration should be unknown. But such condition is not available when it comes to custom as source of international law. Yes, duration is one of the important aspect, but it need not be so long as we discussed in Hindu law. Now the requirement here is they need to have certain timeline, and they should be consistently followed, they should be accepted, and they should be general among the state. That is how we need to see this particular aspect. And the final essential, yes, there need to be recognition for anything to be considered as valid. Now as far as customs is concerned, as a source of international law, it is being respected by statute of the International Court of Justice by bringing that as a source of international law in article 38(1) subclause B. That is how you need to see recognition for the customs. With that, I am concluding this particular presentation. I know I have given a lot of importance for international conventions and treaties and customs as source of law by making two independent videos, because they can be independent questions, whereas the remaining sources like general principles or the writings, they are not that very important. So I will try cover all of them in one single presentation. With that, we can conclude this series also. Thank you so much for subscribing my channel. If you have already subscribed me, if you are yet to subscribe my channel, please subscribe right now. Please like, share and comment my videos. All the very best for whatsoever purpose you are watching my videos, and thank you so much again.